The recent ruling of the OECS Court of Appeal in the matter between Ernest Hilaire and Chastanet has raised a few judicial eyebrows. Legal minds across the region are poring over the significance of the January 16th judgment in favor of the appellant, Prime Minister Chastanet. The attorneys for St. Lucia's Prime Minister argued that the English statute, the Defamation Act of 2013, had been imported into the laws of St. Lucia, and therefore the defences provided in that act of the United Kingdom's Parliament could be relied upon by the Prime Minister. The Court of Appeal agreed with the position of the Prime Minister's lawyers, setting aside the ruling of the High Court. Anthony Estefan, QC, called into Friday's Radio 100 Straight Up program. He says if the Court of Appeal's ruling stands, the implications would be far-reaching.
I think this judgment has caused concern, will cause concern. If the Privy Council said it's right, so be it, then the Parliament of St. Lucia will have to act.
Estefan argues that since the sovereign Parliament of St. Lucia had enacted laws on defamation, such laws enacted by the UK's Parliament could not be imported into St. Lucia's laws, particularly in areas specifically addressed by St. Lucia's laws.
With a sovereign Parliament with unlimited powers of legislation, except in relation to fundamental rights or financial matters, or matters concerning other issues where there are expressed and strict legislative restraints in the Constitution itself. And we felt that if post-independence, any law not deliberated by or passed into law by the Parliament, but which the Parliament believes it's in the best interest of St. Lucia to incorporate, it must do so expressly and explicitly, and that it would be contrary to the constitutional rule of St. Lucia for a colonial law, not even an associated state, a colonial law to be given a construction where post-independence, these laws are still being incorporated, and you can bet your bottom dollar on that without even the knowledge of the Parliament, far less the people of the country and the office of the Attorney General. And we think that's a very far-reaching decision. And you're right, it has severe implications of uncertainty as well. And this is why we advise those who are celebrating premature.
That aspect of the case concerning the importation of English law into the laws of St. Lucia will be brought before the Privy Council in London. Estefan says only St. Lucia's Parliament, in limited circumstances, can allow for laws passed by the UK Parliament to be imported into the laws that it has passed.
The Chief Justice, whether it's part of a dicta or orbited dicta pro incuria, made it very clear that these provisions need to be looked at carefully because of the issue of certainty of law. And everyone is familiar with the common law. We all know the common law is a developing tool of interpretation and offenses and so created by judges over the centuries. The fundamental problem with importation of statutes is that the English Parliament, the way that we see it, would be making laws for the peace, order, and good governance of the United Kingdom. They're not addressing social, economic, political, or legal issues in St. Lucia. That is why it would be for the Parliament, if at all that is possible. There's a caveat with this constitutional prohibition on delegation of sovereign powers.
So
it would be for the independent Parliament to say a specific law or specific part of a law should apply because it has addressed its mind to it.
There's much riding on the outcome of this aspect of the matter between Dr. Ernest Hilaire and Prime Minister Chastanet. The implications go beyond this case between the two politicians and will have an impact, if allowed to stand, on a wide range of the region's laws. Stanley Lucian for the HTS News Force.